Thank you, Worship. 29th of August 2023, State Court Case number 28/113/2023, State against Nandipha Magudumana. The Provincial Judicial Presiding Officer, Mr. Lange, appearing for the State as Matoko, the Court Interpreter, Mr. Makala, and Advocate Dlamini is here for Ms. Magudumana. The Court shall note that on the 8th of August 2023, this matter was postponed to the 11th of October 2023 for further investigation. It is before you at the request of the defense. Perhaps I will then give this opportunity to them to confirm the appearance and the reason we are before you. As you please.
Thank you.
Court pleases, Your Worship, I confirm appearance on behalf of the applicant, who is accused number 4 in these proceedings. I also confirm that the matter is still pending before you, Your Worship, and is coming on a date mentioned by my learned colleague in October. The reason why we are before court is to make a formal application for the applicant to be admitted to bail. The said date was communicated to the state as well as to the judiciary, and we are thus ready to proceed with the application.
Thank you. The State.
As please the Court, Joseph, just before we get to that point, there's a certain legal aspect that perhaps need to be clarified or sorted out before we get to that stage. The Court shall note that on the 8th of August 2023, when the matter was before you, the accused reserved her right to bail, and the defense at that stage placed it on record that the accused was involved in a civil litigation, and as such the right to apply for bail was reserved, and that should there be changes, the state will be alerted. Indeed, the state has been alerted. That is why we are before you today. Perhaps at that stage it was not taken further in terms of what these civil proceedings entail. Joseph, the accused has lodged an application in the High Court, the Free State High Court, where amongst others she sought relief declaring the proceedings in this court as a nullity. That application was dismissed. There was leave to appeal, which was also dismissed, with costs, of course. And subsequent to that, the accused has filed papers on the 17th of August 2023 petitioning the Supreme Court of Appeal, thus pursuing the issue of the nullity of the proceedings. In fact, in the application in the High Court, the magistrate of this honorable court is cited as a fourth respondent. Now the issue, which to my mind becomes a legal issue, is whether the accused, by merely bringing this application to be released on bail, is consenting now to the jurisdiction of this honorable court to hear the matter. That is an issue that I think we need to ascertain, so that we don't find ourselves having transgressed in the legal processes that are currently underway. If we can just get that clarity and
Thank you.
Processes that are pending before the High Court exist separately and independently from these procedures. At all material times, the accused was appearing before you in the lower court, was submitting herself before you in the lower court. The court was at all material times remanding the accused in custody, making sure that there are orders which have been issued against the accused. It has been happening throughout. At no stage did the accused say, I am not going to abide by orders or remands or anything emanating from this court. Her appearing before you is part of the process which is provided for in the Criminal Procedure Act. Whether or not she is subjecting herself into the jurisdiction of this matter, Your Worship, it's of no value whatsoever. As I indicated before you, those proceedings are pending in the High Court. The matter is sub judice. It is a subject matter of the High Court for the High Court to make a decision. And as far as the state has already indicated, the matter is pending there. There is a petition. The matter is still to be decided. There is no order whatsoever that has been made. So the matter as it is, it stands as it is. There is no any order against anybody or against any magistrate or against any respondent. So the status quo remains. Can I take this question, sir?
Yes.
And just one aspect on that. The record will reflect that we never abandon our right to bail. All that we are doing is that we are appearing before you, and for the same rights which we said at the time that we are requesting you to suspend them, and at a later stage you will come and apply for bail. It is not legitimizing or otherwise any process which is pending. All that we are saying is that we are appearing before you. The law allows us to appear before you to make an application. Processes that are pending in the High Court has got nothing to do with this process. As a conclusion.
Thank you. Thank you, sir. Let's proceed then with the bail application.
as it is a petition, the state is ready to oppose it.
Thank you. Can we just get on record the formalities, the schedule?
Yes, it is a Schedule 6. The court shall know that one of the charges is that of corruption, where the state alleged in the charge that the accused, together with 11 other accused persons, acted in concert on a doctrine of common purpose, and therefore the relevant schedule is Schedule 5, as it is.
Schedule 5.
Schedule 5, yes.
Thank you.
Here, my letter correctly, Your Worship. First started by saying Schedule 6. Is it now correctly himself to say Schedule 5?
Yes, he initially
He started by saying Schedule 6. Is he correcting himself to say Schedule 5?
Yeah, he initially said Schedule 6, but he corrected himself and said Schedule 5. So I think we are all.
Thank you, Lord. Thank you, Your Worship.
Thank you. On the same page. Can we proceed then?
Thank you, Your Worship. We are ready to proceed.
Can you confirm the schedule? It is 5.
We confirm that looking at the nature of charges preferred against the applicant, they are charges which falls within the ambit of Schedule 5. And for that matter, we are ready. We have prepared affidavits upon which we have decided to put our case before you through the affidavits.
Thank you, sir. You may proceed.
With your permission, Your Worship, we have prepared a copy for Your Worship as well as for the state, and with your permission, I would request your leave to read the affidavit of the applicant into the court.
Thank you, sir. You may do that.
Spot, please, Your Worship. This is the affidavit of Nandipha Magudumana, and it reads as follows: in the magistrate court for the district of Mangaung, held at Bloemfontein, in case number 28/113 of 2023, in the matter between Nandipha Magudumana, the applicant, and the state respondent, affidavit in support of bail application. I, the undersigned Nandipha Magudumana, do hereby make oath and state as follows. Paragraph 1. I am an accused and an applicant in this bail application which seeks relief from this honorable court to be released on bail. I am an adult female aged 34 years of age. Paragraph 2. I respectfully submit that I will demonstrate herein that it is in the interest of justice that I be released on bail. Paragraph 3. In an event, the details of fairness and justice in view of the peculiar facts herein warrant that I should not be deprived of my liberty and that I should be released on bail. Paragraph 4. I make this affidavit out of my free will and will not in any way be unduly influenced to impose hereto. Paragraph 5. The facts contained herein are within my personal knowledge unless the contrary appears from the context, and are both true and correct. Where I make legal submissions, I do so on the basis of advice provided by legal representatives. Paragraph 6. Purpose for application. 6.1. The purpose of this affidavit is to provide the Honorable Court with my personal circumstances and to address the factors to be considered by the Honorable Court as contained in Section 60 subsection 4 to Section 60 subsection 9 of Act 51 of 1977. 6.2. I have been advised by my legal representatives that my bail application will result under Schedule 5 of the Criminal Procedure Act 51 of 1977 due to some of the charges preferred against me. 6.3. I have furthermore been advised and fully aligned to such advice that I bear the burden to show that the interest of justice permits my release and that I am obliged to initiate this application. Paragraph 7. Personal circumstances. 7.1. I am a South African citizen by birth. I was born in Port Edward, KwaZulu-Natal province on the 4th of September 1988. My South African ID number is 880904054184. 7.1.2. I attended Port Shepstone High School where I matriculated. 7.1.3. Prior to my arrest in Tanzania, I resided for a period of approximately 2 years at number 22A 2nd Road, Hyde Park, Sandton, Gauteng Province. 7.1.4. I previously stayed for a period of 10 years at house number 35B, Townsend, Bedford View, being my marital home until I separated with my husband for reasons which I will not divulge for purposes of this bail application. My apologies, Lordship. I should have written I will not advise. I will not divulge. I intend staying with a friend at number 7, Aragon Estate 158 Helen Road, Sundown Extension 56, Sandton, Johannesburg, Gauteng Province. The Honorable Court is referred to a copy of an affidavit from my friend confirming same marked as Annexure FA1. I do not have relatives that I know of outside the Republic of South Africa, and I do not possess any assets outside the Republic of South Africa. 7.7. I have permanently resided in the Republic of South Africa my entire life. 7.1.8, I have no intention to relocate to any other country. The travel documents. 7.2, I have one South African passport which was confiscated during my arrest in Tanzania. I thus currently do not have any travel document in my possession. 7.3, family background. Both my parents are still alive and they permanently reside at 632 5th Street, Port Elwood. I have 3 siblings. I'm currently married but separated with my husband. I have 2 minor children, girls aged 11 and 6 years respectively. My 11-year-old is at grade 5, while 6-year-old is at grade 1. I have full parental responsibility and rights of my 2 minor children in terms of Section 18 of the Children's Act 38 of 2005. I have specific parental responsibilities and rights with regard to primary care, including primary residence of my 2 minor children as contemplated in Section 18(2)(a) of the Children's Act 38 of 2005. Tertiary education and work history. I possess the following tertiary education: BSc in Health Sciences as well as an BCHB from University of Witwatersrand. I'm a medical practitioner and a founder of Optima Medical Aesthetics, a skincare and aesthetic clinic in Sandton. I was until my arrest still practicing at the said clinic. I earn approximately 50,000 rand per month. 7.5 assets. I own various movable properties including furniture and household possessions as well as my medical practice equipment, cumulatively to the approximate value of R1 million. I do not own any fixed assets. Criminal history. 7.6. I have no previous convictions and there are no pending criminal cases against me. I also declare that I have no knowledge of any outstanding warrants of arrest against me. I further declare that I do not have any order against me as contemplated in Section 5 and 6 of Domestic Violence Act of 1998, nor do I have an order against me as contemplated in Section 3 and Section 9 of the Protection from Harassment Act of 2011 or any similar order in terms of any other law. Paragraph 8, circumstances around my departure from South Africa. I have been advised that I have the right to remain silent and not reveal the basis of my defense, and that I should reveal the basis of, and that should I reveal the basis of my defense, it may be used against me at the ensuing trial. Albeit I have decided to exercise and assert my right to remain silent and not to disclose the basis of my defense until at the appropriate time and forum, I nevertheless wish to provide the following context to how I departed South Africa. 8.1. On or about the 17th of March 2023, I was in company of accused number 5. 8.2. I was instructed and commanded by accused number 5 to get into a vehicle and leave the premises to a destination unknown to me at the time. 8.3. I refused and wanted an explanation, but he forced me into a vehicle. 8.4. I succumbed to the pressure due to the threats he directed at me. 8.5. I was defenseless, helpless, and with no one to report to at that time. 8.6. I complied with his instructions and was taken out of the country against my will. Should read 8.7. At all material times, I had no control over the situation because I was scared of the threats made by accused number 5. 8.8. I submit that I did not voluntarily depart from the Republic of South Africa as demonstrated above. And 8.9. In any event, I had no reason to leave the Republic of South Africa. Paragraph 9. The salient factual background on my arrest. 9.1. On the day of my arrest in Tanzania, I was apprehended by members of the South African Police Services who called me by my name and were communicating in Isizulu language. I was then taken into custody in an unknown facility. 9.2. Upon my arrest, the said members of SAPS discovered passports inside the cubby hole. I was later informed that one of the passports belonged to me. At all material times, I was not aware that my passport was in the air. 9.3, I remained in custody in Tanzania, where I enlisted the services of one advocate Sambo to provide legal service. 9.4, I was however taken to South Africa through methods which are currently being legally challenged. 9.5, I have been in custody at Biza Mahate Correctional Facility since 13 April 2023 to date. 9.6, as indicated, I have challenged the legalities of my apprehension and arrest in Tanzania by officials of South African Police Services and the Department of Home Affairs, as well as my subsequent unlawful return to the Republic of South Africa. 9.7, albeit the application was unsuccessful, I have launched an application for leave to appeal at the Supreme Court of Appeal. 9.8, I initially reserved my right to launch bail application at an appropriate time. The said approach was informed by my fierce challenge of the illegal abduction and subsequent extradition disguised as deportation, by which the High Court confirmed to be so. Paragraph 10, the charges. 10.1, I have been informed that I am being charged with the following. 10.1, aiding, escape, concealing and harboring. 10.1.2, 2 counts of violating a body, and 10.1.3, 2 counts of fraud. It should read 2 counts of fraud and not fraud counts maybe. 10.2, I intend pleading not guilty to the charges preferred against me by the state. 10.3, I have been advised that I have the right to remain silent and not reveal the basis of my defense, but should I reveal the basis of my defense, it may be used against me at the ensuing trial. I have decided to exercise and assert my rights to remain silent and not to disclose the basis of my defense until at the appropriate time and form. Legal submissions, paragraph 11, 11.1. In order to persuade the above honorable court that I should be released on bail, I provide the following additional facts and information in terms of section 60 of the Act 51 of 1977. Paragraph 60, 4A, being danger to public or individual safety. 11.2.1, I respectfully submit that there is no likelihood that my release on bail will endanger the public safety or that of any particular individual. 11.2.3, I have no history of violent behavior, nor do I have any predisposition to commit offences referred to in Schedule 1 of the Criminal Procedure Act 51 of 1977. 11.2.4, I will also not commit any offences against any person in a domestic relationship as defined in Section 1 and 5 of the Domestic Violence Act of 1998, or any offence referred to in the Protection from Harassment Act of 2011. Section 60 subsection 4B, evasion of trial. I respectfully submit that there is no likelihood that I will attempt to evade my trial. 11.3.2, my arrest in Tanzania is currently a subject of litigation in the Supreme Court of Appeal. I, however, wish to highlight that my deportation to South Africa was declared by the Free State High Court to be a disguised extradition and thus unlawful. I do not intend to belabor the point any further for reasons alluded in observance of sub judice. 11.3.3, I submit that this is evident from my conduct since the inception of the investigation. I have not supplied any false information, nor have I supplied any false information for the purpose of this application. I undertake to attend court faithfully on each and every occasion to which this case might be postponed to. I have no intention to live the life of a fugitive. 11.3.4, I submit that the likelihood of absconding trial has to be evaluated in terms of Section 6, subsection 9 of the CPA, balancing the interest of justice with my right to personal liberty. 11.3.5, I will stand by my trial should it proceed against me. I am a well-known medical practitioner and there is no possibility that I will even think of not standing my trial. 11.3.6, 11.3.6, I submit that any objections to my release on bail could be accommodated by bail conditions. Section 60 subsection 12 of the CPA provides possibility of imposing alternative bail conditions that can be used to minimize the risk if there is of absconding. 11.3.7, such conditions include inter alia, being required to report the police station at regular interval as the case may require. This I submit shall ensure that I can be located. 11.3.8, finally, submit that the use of bail conditions as delineated above is a clear way to ameliorate the competing interest of risk of absconding with fairness to the bail applicant. Paragraph 11.4, section 60 subsection 4c, read with section 60 subsection 7 of the CPA. I confirm that a list of state witnesses has been furnished by the state to my legal representatives. I, however, wish to categorically state that I do not know the identity of any witness upon whom the state will rely in order to attempt to prove a case against me. In any event, I have no intention to interfere with any witnesses, as I have no cause to do so, and I undertake not to do so. There has not been any allegation that I have attempted to influence or intimidate witnesses. I therefore respectfully submit that there is no likelihood that this subsection is at risk to be infringed upon should I be admitted to bail. As previously stated, I have no previous convictions and I have not been released on bail pending any charges. I am, however, willing to comply with reasonable conditions of bail in this regard should the Honorable Court deem it appropriate to impose such conditions. 11.5, section 60, subsection 4d, jeopardy to the functioning of criminal justice system or bail system. I submit respectfully that there is no likelihood that this subsection is potentially to be infringed upon should I be released on bail. I have not furnished any false information to the investigating officer, nor have I furnished false information for purposes of this bail application. Section 60, subsection 4e, exceptional circumstances in brackets presence or absence which may lead to undermining public order or peace. I was advised by my attorney, which advice I accept, that this factor is not applicable to my application. All co-accused in this matter, with the exception of 2 accused, have been admitted to bail. There has not been any public disorder as a result thereto. I will be able to raise an appropriate amount proposed as bail in the amount of 10,000. Relief sought, paragraph 12. In the premises, and taking into consideration the relevant schedule the charges result under, I respectfully submit that I have, on the preponderance of probabilities, proved the existence of interest of justice that may be granted to me in an appropriate, affordable amount of 10,000 rand, and with such conditions attached as the court may deem fit. The affidavit has been duly signed by the applicant Nandipha Magudumana and also commissioned by the Commissioner of Oath in South African Police official. And Your Worship, I also wish to read the confirmatory affidavit referred to here in this affidavit as part of the application. It's a confirmatory affidavit and it reads as follows. I, the undersigned Natati Michelle Chibaya, do hereby make an oath and say that I'm an adult female with identity number 880523125618, currently employed as a medical doctor for the Department of Health, Gauteng, and residing at house number 7, Aragon Estate, situated at 158 Helen Road, Sundown, extension 56, Sentin, Johannesburg, Gauteng. I own the said place and have been staying at the mentioned address since 1st of January 2022 to date. The facts deposed to herein are within my own personal knowledge and are, unless the converse appears otherwise from the content, to the best of my knowledge and belief, both true and correct. 4. I have read the founding affidavit of Nandipha Magudumana and confirmed the contents thereof insofar as they relate to me. 5. I confirm that Dr. Nandipha Magudumana will be residing with me at the said address. The affidavit has been signed by the deponent Natsai Michelle Chibaya and duly commissioned by members of South African Police Services today on the 29th day of August 2023 at Centen at Clyde Service Center. Attached to the affidavit, the court will see it is an identity document of the deponent of the confirmatory affidavit, as well as the attached tax invoice on the ESCOM depicting the address and the details of the deponent of the confirmatory affidavit. With your permission, before it gets entered in, may the court confirm the correctness and the accuracy of the affidavit made by the applicant of this matter.
Thank you. Ms. Magudumana, do you confirm that this is your affidavit? Do you confirm that it is correctly recorded? Thank you. I'll receive it.
Court business, Your Worship, I wish to hand in the affidavit as an exhibit before court.
I'll receive it as Exhibit H. Can I please have the signed affidavit? The one that was handed to me is not signed. It was just a copy. Thank you.
My apologies.
Thank you.
Court please, Your Worship, as the affidavit has been handed in, that will then complete the case for the applicant. Court please.
Thank you. Advocate Matloko.
Thank you, Your Worship. Can I ask that we adjourn the matter until 2 o'clock? Reason being that there is no information that is contained in the affidavit that was submitted that still needs to be followed up, especially the new address that has now been given. I just ask that we adjourn until 2 o'clock and the state will then be most probably be ready by then. That's it, please.
Thank you. Is it suitable to the defense?
So, to ask Your Worship.
The court will then adjourn and we'll proceed at 2 o'clock.
Thank you, Worship. May I recall the matter of Nandipha Magudumana? Before then, Your Worship, let me apologize for the delay. When we adjourned, I requested until 2 o'clock, but unfortunately, getting some of the information took a little bit longer. I wish to apologize, but the legal team was kept up to date all the time.
Thank you. Your
Thank you.
apology is accepted.
Thank you very much, Joseph. Joseph, the state will likewise oppose the bail application, also by way of an affidavit. I'm providing the legal team with a copy of the affidavit. It is an affidavit by the investigating officer, Colonel Flyman, and I wish to read it into the record if the court allows it.
Yes, please. You might proceed.
Bail opposing affidavit in the matter between Nandipha Magudumana, the accused stroke applicant, versus the state, and it reads thus: I, the undersigned, Diego Jobo Flyman, I am Lieutenant Colonel in the South African Police Services, stationed at the Provincial Organized Crime Investigation Division, Bloemfontein. 2. Save where the contrary appears from the context, or where I declare otherwise, the facts deposed to in my statement are within my personal knowledge and are otherwise, to the best of my knowledge, true and correct. Thirdly, I am the investigating officer in this matter. Fourthly, the applicant and 11 other accused will stand trial in the High Court, Bloemfontein, on charges as per annexures to the charge sheet. Paragraph 5 deals with the summary of the facts. The applicant, a married woman, is in a relationship with accused 5, Thabo Bester, herein referred to as Bester. Bester was convicted on counts of murder and rape. He is serving a life sentence and was incarcerated at the Mangaung Correctional Prison, herein referred to as G4S. 5.2. The applicants co-accused, that is accused 1, 6, 7, 8, 10, 11, and 12, were employed at G4S. Accused 2 is the applicant's father. Accused 9 was a gardener. Accused 3 was an IT specialist at G4S. The above mentioned accused acted in the furtherance of a common purpose in committing these crimes. Their purpose was that Bester must escape. 5.4. The applicant and Bester are masterminds of the planned escape. 5.5. On or about the 7th of April 2022, the applicant collected and claimed an unidentified body, which was unclaimed from State Mortuary in Bloemfontein, under the false pretense that the body was that of her father, Zingiza Magadla. She then arranged for a funeral and burial of the said body in the early hours of the morning, citing cultural practice. On digging the grave on the 2nd of April 2023 to exhume the body, only rotten meat was found inside the coffin, but no human remains. 5.6. During my investigations, I discovered and confirmed that the applicant booked into a boutique hotel in Bloemfontein during the periods 24 to 28 March 2022, 29 to 30 March 2022, as well as 13 and 14 April 2022. I further discovered that the 3 bookings were made by one TK Nkwana. This is one of the earliest names used by accused 5. 5.7. The first attempt to facilitate the escape was abandoned, and the body was later discovered floating in the Kopano-Nokeng River here in Bloemfontein. This body is still at mortuary waiting to be claimed. 5.8. On 23rd April 2022, the applicant and accused 9 approached the mortuary at National Hospital Bloemfontein to claim another unidentified body. On the 27th of April 2022, one Katleo Nkwana hired a rental car at O.R. Tambo International Airport in the name of the applicant's father, that is accused 2. 5.10. This rental car was used on the 29th of April 2022 to smuggle the above-mentioned body into G4S Correctional Facility and hid in the workshop. 5.11. In the early morning hours of 3rd May 2022, the body was smuggled in Bester's cell with assistance of all accused with exception of accused 2. The body and the cell were then set alight with intent to create the impression that accused 5 committed suicide in cell 35. 5.12. Bester escaped after the CCTV system was disconnected. A charred body was then found in Bester's cell. 5.13. On 5 May 2022, the applicant, together with accused 2, claimed the charred body found in cell 35 as that of Bester. In claiming this body, the applicant submitted an affidavit dated 5 May 2022, commissioned at Polokwane to a G4S official, wherein she declared the deceased to be her partner who has no other relatives. 5.14. The applicant arranged for the body to be transported to Gauteng for cremation. 5.15. After the transportation of the body to Gauteng, the South African Police Services, SAPS, received the preliminary post-mortem findings stating the cause of death to be blunt trauma to the head, and further that there was no signs of smoke inhalation. We, in bracket SAPS, immediately stopped the release of the body to the applicant for burial or cremation. In the process, we traced the biological mother of Thabo Bester. It was later confirmed through DNA that indeed she was the mother to Thabo Bester. 5.16. On the 20th of May 2022, the applicant lodged an urgent application in the High Court of Northern Gauteng, Pretoria, where I was cited as the 3rd respondent. She requested the court to declare, amongst others, her as the customary law wife of the deceased, Thabo Bester, that she has the burial rights of her deceased husband, that the South African Police Services, SAPS, immediately released the body of the deceased into her possession, that the police be stopped from harassing her, and ordering the Department of Home Affairs to release the form which states the cause of death of the applicant, Nandipha Magudumana. That's how it is in the papers, in order to facilitate the autopsy as well as burial of the deceased. In her founding affidavit, she declared, amongst others, that she was the customary wife of Bester, that they met in 2006 while they were studying at the University of Witwatersrand, while Thabo Bester was doing first year in theology, during which time she was at medical school. That in 2007, the deceased continued his studies at the University of Cape Town, and he continued his studies in prison, and that they started dating on the 21st of May 2017. She further declared that the deceased graduated with an LLB and that she enrolled him for a course in Damelin. That in February 2020, the deceased proposed marriage to her, and that the Lobola negotiations took place on 14 December 2020. She declared further that the said David Magagula has since passed away in 2021. She declares that she does not know any relative of the deceased, and that the deceased mother died while he was young, and that he was brought up by his grandmother, who also passed away when he was 12 years old. Insofar as the customary marriage, accused 2, who is the father, attached a supporting affidavit declaring that on the 14th of December 2020, a certain Mr. David Magagula arrived at his place to conclude lobola negotiations, and that 60,000 rands was paid for customary marriage. Attached hereto is a copy of the notice of motion with the applicant's founding affidavit marked Annexure A. During this application, I discovered a letter dated 16 May 2022 by the applicant's attorney, one Vuyo Manisi, threatening to institute an urgent High Court interdict if the deceased remains were not released to the applicant on or before 5 o'clock of the same day. On 20 May 2022, the court order was, and he quotes it, "The matter stands down to 24 May 2022, unquote. On 20 April 2023, this year, the court ordered the matter be removed from the roll with costs. Another court order, that's now paragraph 5.19, Your Worship. Another court order, also dated the 20th of May 2022, was served on the respondent's legal representatives. According to this order, the matter was postponed to 24 May 2022, and that the body must be released to the Hillbrow mortuary before 22 May 2022. Both these orders were relating to the same case, in brackets, case number 27479 of 2022. 5.20. The second order, which is prima facie false and involving the same legal firm of Vuyo Manisi, is currently under criminal investigation. 5.21. In March 2023, there was a media article about the applicant and accused 5 shopping together at a mall in Gauteng. 5.22. Upon further investigations, I established that the applicant claimed and buried another unidentified body, which she claimed to be that of Themba Ndlovu, a brother to accused 9. The funeral was held at the same place and time as the first funeral. Upon digging the grave, Your Worship, I see it's written graves. It must be grave. Upon digging the grave to exhume the remains, we discovered 3 times 10 kg bags of meal were in the coffin with no human remains. It was established by means of fingerprints and DNA that the charred body found in cell 35 was that of Katlego Bereng. 5.24. My investigation revealed that accused 1 was promised 7 million rands to orchestrate the escape. He enlisted the assistance of his co-accused, that being accused 3, 6, 7, 8, 10, 11, and 12. It was later discovered that applicant made payments of 85,000 rands to accused 1. 5.25. On 7 April 2023, the applicant, accused 5, and a Mozambican national were spotted and arrested by Tanzanian authorities in Arusha, Tanzania, on transit to Kenya. On 12 April 2023, the Tanzanian authorities issued the applicant and accused 5 with a notice that they were prohibited immigrants in terms of their immigration laws. They were ordered to leave Tanzania within 3 days by escort. The applicant and accused 5 were arrested on 13 April 2023 on landing at Lenzaria Airport from Tanzania. 5.26. The applicant lodged an urgent application to the Free State High Court where I am cited as respondent number 3, praying that the court declare her apprehension, arrest, and abduction and subsequent transportation to the Republic of South Africa to be wrongful and unlawful. To declare her arraignment before the current magistrate's court be nullified and set aside the criminal proceedings against her. To direct orders and warrants by magistrates to detain her at Biza Makatu, null and void, and to declare her to be discharged from detention. This application was dismissed with costs. The costs involved are estimated at 600,000 rands. The application for leave to appeal was also dismissed with costs. A petition to the Supreme Court of Appeal, SCA, was filed on 17 August 2023 and is still pending. Paragraph 6. The applicant is applying for bail. I believe this application falls within Schedule 5 of Act 51 of 1977. Paragraph 7. This application for bail is opposed for the following reasons. 7.1. Section 60, subsection 4B of Act 51 of 1977. That is, there is a likelihood that the accused, if she is released on bail, will attempt to evade her trial. A. The merits and background provided in paragraph 5 speaks for themselves. B. When charging the applicant on 14 April 2023, she provided me with the address S22A 2nd Road, Hyde Park, Sandton, Johannesburg. C. Upon my investigation to confirm this address, I obtained a statement from Fortune Property Smith, an estate agent that leased out this property to the applicant. He stated that around 2018, the applicant rented one of their properties at number 12 Aston Street, Sandton. When the rental period came to an end, the applicant approached him to lease the house in question, that is 22A 2nd Road, Hyde Park, Sandton. He states that when she came to view this property, and at all times during the negotiation, a person who identified himself as Tom Katlego Motsepe Nkwana will join them on a video. This person will comment and make suggestions on specifications for renovations. D. The applicant later proposed to move her business to this property and started renovations on the one side of the property. At some stage, the applicant started falling behind with rentals, and sometimes in August 2022, he met face-to-face with Tom Katlego Motsepe Nkwana together with the applicant and they proposed to him to use the place for events. E. On 21 March 2023, the applicant and the said Thomas Katlego Motsepe Nkwana removed their belongings from this property, and that was the last time that they were seen on this property. This was the same period that the media covered their public appearance. I obtained the lease agreement and discovered that the lease agreement was signed on 15 January 2021 and was valid until 14 January 2023, and that the signatories were the applicant and TK Nkwana. I later discovered that the said Tom Katlego Motsepe Nkwana is one of the alias names used by accused 5. F. The above-mentioned estate agency further revealed that the applicant had also rented another property at 64A Colony Drive, River Club, for use and occupation by her parents. On 24 March 2023, the applicant instructed the parents to urgently and immediately vacate the property. Again, this was the same time that the media exposed them. Thus, when providing me with this address on 14 April 2023, the applicant knew she was no longer staying at this address as the contract expired in January 2023 and had unceremoniously vacated the property on 21 March 2023. She thus provided me with false information and deliberately misled me. G. The applicant qualified and practiced as a medical doctor. During the course of my investigations, I obtained an affidavit from the Health Profession Councils of South Africa on 14 April 2023. Amongst others, it is declared that the applicant was registered with the council in the category of public service community service with effect from 1st January 2016 until February 2017, when she was registered in the category independent practice medical practitioner. However, the applicant was suspended on the 1st of December 2021 for failure to pay the prescribed fees. Therefore, at the time of arrest, she was no longer permitted by law to practice as a medical doctor. The address where her practice was situated is 3 Lower Road, Green Park, Morningside, Sandton, Johannesburg. During my investigation at CIPC, that is Companies and Intellectual Property Commission, I established that the medical center is registered with a different address, that of 35B Townsend Road, Bedford View, Johannesburg. It is registered as a private company under the name Optimum Medical Holding Group, Pty Ltd. H. My investigation at CIPC further revealed that the applicant's name features in the following companies. Firstly, TBM Pty Ltd. She is registered as a director with 3 other shareholders. The registered address is 219 Broadcrest Country Estate, Gauteng. 2. SACO, SACO Investment and Capital Fund Pty Limited. She is registered as a director, but it appears she has since resigned. The registered address is 22 George Avenue, Rivonia, Extension 1, Sandton. 3. Doctors Network Legacy Pty Ltd, where she is registered as a director. The registered address is 35B Townsend, Bedford View. 4. One or I Medical Life Pty Ltd, where she is registered as a director. Registered address is ground floor, Green Park Corner, Sandton. iCoin Group Pty Limited, where she is registered as well as a director, with a registered address as ground floor, Green Park, Sandton. Then the other company is Arum Holdings Pty Limited. She is registered as a director with a registered address as 17 Hamptons Bush Willow Park, 87 Greenstone Drive. On 8 August 2023, the High Court Gauteng Local Division under case number 37069/2023 ordered this company to pay 2.8 million rand and 272,000 rands to the two applicants in that matter, that being Lloyd Marcus Tebogo Maduani and Mapuleng Plantina Maduani. I, paragraph I, the applicant is married with 2 minor children that are school going. The 2 children are currently staying with the father. The applicant deserted the children since March 2023. She decided to elope with accused 5 while she was still a married woman. I have since established from correctional services that the applicant was never visited by her husband and children since her arrest and detention. It has also been established from the telephone register that there was only 1 telephone call to the husband. Instead, the many telephone calls were to friends and her legal team. J. In terms of properties, there are no properties registered in her name at this office. However, established she owns 3 cars, that being a Porsche, Opel Corsa utility, and Volkswagen. The Porsche in question was used in Bloemfontein during the so-called funerals mentioned above. The applicant fetched accused number 5 from KwaZulu-Natal after the escape using this same Porsche. A tracker confirmed this movement. The applicant left this Porsche with her security when she fled the country. It is currently impounded in Northwest. Paragraph K. The applicant has a valid passport that was issued on 16 February 2017 and will expire in February 2027. It has been established from the Department of Home Affairs that since the issue, this passport was used 23 times for trips outside South Africa. At the time of arrest, she was in possession of 2 other passports belonging to somebody else. Statement of owner of these passports was obtained. She declares the applicant deceived her in handing her these 2 passports. Upon scrutiny of the passport of the applicant, it was established she did not use the passport when she fled the country. This was further confirmed by Home Affairs. This passport was only stamped on arrival at Zaria airport from Tanzania after her arrest. Pardon me for that. L. The applicant has everything to lose by remaining in the country. There are further criminal cases that has since been registered against her. These are the following. Sinoville case 206 of 4/2023. It's a fraud matter where the amount involved is 15 million rands. Santon case 87 of 4/2023, fraud amounting to 500,000 rands. Runback case 269 of 2/2023, fraud amounting to 1.2 million rands. Benoni case 348 of 8/2023, fraud amounting to 5.112 million. Thank you. My apology. Durban North case 1 of 7/2023, fraud amounting to 150,000 rands. Runback case 269 of 3/2023, fraud amounting to 900,000 rands. Paragraph M. The applicant is not only facing long term of imprisonment if she is convicted on the above mentioned matters, but is also facing further civil claims. The applicant is facing a long term imprisonment regarding this matter. As previously stated, the applicant left the country illegally and was traced in Tanzania. South Africa does not have an extradition treaty with Tanzania. Extradition is nonetheless a long and protracted process. In the matter of State versus Diwani, his wife was killed while on honeymoon in November 2010. He was only extradited in April 2014. Paragraph N. The applicant is facing serious charges. The state has an overwhelming case against the applicant and is linked to the crimes as follows. Count 1, fraud. There's direct evidence, eyewitnesses who confirmed that the applicant claimed the body and arranged for a fake funeral. Count 2, violation of a body. The very same body that the applicant claimed was recovered in the river and in the grave was rotten meat and not a body. Count 3, the contravention of Section 3B of Act 12 of 2004, that is corruption. The applicant and a co-accused acted in the furtherance of a common purpose. Their aim was that Bester must escape. The objective evidence of bank statements shows that the applicant was also on occasions a source who provided the money to accused 1 for distribution to their co-accused. So far, it has been established the applicant paid 85,000 rand to accused number 1. Count 4, the contravention of Section 31A of Act 12 of 2007, should be 4, corruption. See the summary provided regarding count 3. Count 5, fraud. Direct evidence and eyewitnesses who confirmed that the applicant and the accused 9 claimed the then unidentified body. The objective evidence is that the applicant's fingerprints was on the claim form. It is required that the person who claims such a body must give his or her fingerprints. Count 6, arson. To facilitate the escape of Bester, the unidentified body and Bester's cell were set alight. See also count 8 to 12. Count 7, violation of body. There are direct evidence, eyewitnesses, that the applicant arranged a fake funeral, that the applicant fraudulently claimed the body, count 5, as that of Bester. When claiming this body, she also made a false statement to the police. The applicant introduced herself also as Dr. Nandipha when she claimed the body of Bester in Haggis. Count 8, assisting an inmate to escape. See the contents of the evidence, count 7. Count 9, assisting an inmate to escape. See the contents of the evidence, count 8. Count 9, assisting an inmate to escape. See the contents of the evidence, count 7. Count 10, assisting an inmate to escape. See the contents of the evidence, count 9. Count 11, assisting an inmate to escape. See the contents of the evidence, count 11. Count 12, assisting an inmate to escape. See the contents of the evidence, count 12. Count 13, assisting an inmate to escape. See the contents of the evidence, count 13. Count 14, assisting an inmate to escape. See the contents of the evidence, count 14. Count 15, assisting an inmate to escape. See the contents of the evidence, count 15. Count 16, assisting an inmate to escape. See the contents of the evidence, count 16. Count 17, assisting an inmate to escape. See the contents of the evidence, count 17. Count 18, assisting an inmate to escape. See the contents of the evidence contravention of Section 115E of Act 111 of 1998, harboring and concealing an escaped prisoner. The applicant rented a house in Sandton where she and Bester stayed. There is a lease agreement and files that were seized on these premises after the arrest. The applicant and Bester were seen by members of the public in each other's company. They also committed further fraud after the escape. There was even security to protect them at this house. Count 10, defeating the ends of justice. See the summary provided regarding count 5, 6, and 7. Count 11, fraud. Direct evidence, eyewitnesses implicated the applicant. See the summary provided regarding count 5, 6, and 7. Bail condition would not prevent applicant to flee the country. She evaded the police for 11 months. She fled the country and did not use a passport when she left South Africa. She has no respect for the law and even tried to use the legal system to get hold of the body. She brought an application that the body, count 5, must be released and that the police must be interdicted from harassing her. She stated that it is Bester's body and that she is his customary wife. She stated that she and Bester met whilst they were studying at Wits University. Bester studied theology. Whilst Bester was in custody, Bester obtained his LLB degree. She lied about the death of David Magagula. It has been established that the uncle to Thabo Bester is Klaas Magagula, who is the uncle to accused 5 and who confirmed there was never a David Magagula. 8.3, Section 60, subsection 4C of Act 51 of 1977. The likelihood that the applicant, if she is released on bail, will attempt to influence or intimidate witnesses or conceal or destroy evidence. Some of the witnesses are known to the applicant. The counts of corruption are an indication that she could influence witnesses. 8.4, Section 64D of Act 51 of 1977. The likelihood that the applicant, if released on bail, will undermine or jeopardize the criminal justice system, including the bail system. A, the applicant, knowing that the information is false, brought a false application for the release of the body. B, the applicant, knowing that it is false, alleged in the High Court of Bloemfontein that she was kidnapped from Tanzania. 8.5, Section 64E of Act 51 of 1977. The exceptional circumstances that the public peace or security or likelihood that the release of the applicant will disturb the public order or undermine the justice system. A, the nature of these offenses induced a sense of shock to the community. It was well-planned operation. A convicted rapist and murderer was back in the community. D, there was a total disrespect towards the dignity of the two bodies that they claimed. The second body, Katlego Bering's family, was heard and still has more questions than answers. E, these crimes jeopardized the public confidence in the criminal justice system. The persons who were to ensure that a dangerous person, Bester, was locked up, was put back on the streets because of corruption. F, corruption is a huge problem in our country, and hardly a day went by when the enormous proportion of corruption is not in the media. G, the applicant has no respect for the justice system, as previously mentioned. H, as a result of these crimes that were committed, a parliamentary committee investigated these crimes. Paragraph 9. there is a substantial incentive for the applicant to evade a trial. 10. I have had the opportunity to scrutinize the affidavit by the applicant and wish to state the following. 10.1. At paragraph 7.1.5 of the affidavit, I also scrutinized the supplementary statement by one Natsai Michelle Chibaya. I have since established that Natsai Michelle Chibaya is a Zimbabwean citizen who obtained permanent residence in the Republic of South Africa only in July 2018. Her residential address on the system of the Department of Home Affairs is 31 Kwela Close, 16 Maiven Avenue, Douglasville, Johannesburg. The fact that this person has been staying in this address only from January 2022 is concerning. I wish to state further that accused 9 is a Zimbabwean who was employed by the applicant first as a gardener and later promoted to a security guard. A black Mercedes-Benz, which was rented by the applicant, which she never returned, and which was later found abandoned in Zimbabwe when she was still at large. This is evident that the applicant has close ties with Zimbabwe. Her friendship with this person she states she will stay with is concerning. 10.2, at paragraph 7.4 of her affidavit, she states, amongst others, she was practicing as a medical doctor until her arrest. As stated above at 7.1g, the applicant was suspended from practicing as a medical doctor in December 2021. If she had been practicing as she alleged, this was unlawful. Paragraph 10.3, at paragraph 8.2, I categorically dispute this allegation. And this was the allegation that she was sort of kidnapped, put in a car, and she found herself in Tanzania. Through thorough investigation, I have established that the applicant was the one who drove from Johannesburg to fetch accused 5 from KwaZulu-Natal after his escape. As stated at paragraph 7.1e above, the applicant and accused 5 rented out a house together. They are both signatories to the lease agreement. My apology. The two, that being applicant and accused 5, were spotted shopping together by the media in March 2023. The applicant and accused 5 traveled together and stayed in Cape Town, where, amongst others, the applicant wrote out a prescription for accused 5 and visited a salon together. Looking at how the applicant is involved and the role she played in the escape of accused 5 as outlined above, there is no piece of evidence that she was at any stage forced and or threatened in any manner. Prior to the escape of accused 5, the applicant stayed in one of the boutique hotels in Bloemfontein in March 2022 and April 2022 in what looks like facilitation of the escape. The applicant is currently detained in Kroonstad, while accused 5 is detained in Pretoria. Since her arrest, no case was opened of kidnapping. The applicant and accused 5 has been appearing before this court on more than one occasion. They appear showing there is affection to each other. They were seen holding hands and smiling to each other. See example, a picture of them during the last appearance on 8 August 2023, attached as Annexure B. paragraph 10.4, at paragraph 8.3, 8.4, 8.5, 8.6, 8.7, and 8.8. As appears from 10.3 above, the applicant had been freely moving around in KZN, Gauteng, and the Western Cape. There is a border post between South Africa, Zimbabwe, and Zambia to reach Tanzania. The applicant had ample time to alert any of the authorities about the so-called forced removal. The estimated distance between South Africa and Tanzania is 3,400 kilometers. This is all I can declare, and it is commissioned, Your Worship, and signed at Bloemfontein today, the 29th of August 2023. I wish to submit it as Exhibit J, as a basis.
Thank you. The affidavit is received and it's marked Exhibit J.
And that is my case. Thank you.
Thank you, Advocate Lamini.
Your Worship, I'm looking at time now. It's 10 to 4. We definitely have to address you, of course, before you give your ruling on the matter. In the light of time and the volume of aspects which we need to address you on in relation to this bail application, and the matter for the fact that it is actually set down for 2 days, I would propose that we roll it over until tomorrow for both the applicant and the state to address you before judgment.
Thank you.
Yes, please.
The state?
That would have been my request as well, Your Worship. I want to further propose that we, considering it's almost after our work, that we make it what time? Advocate Lamini, 11 o'clock, 12 o'clock? I will not be ready by then. 11. Yes, I propose that we adjourn it until 11 o'clock to enable me to prepare properly for my address. Yes, please.
May I please ask that you prepare your address in writing so that I can refer back to it when I prepare my judgment.
Pardon me, sir?
Will you please do your arguments in writing for me?
It's an order.
The defense and the state, so that I can just refer back to it when
As
I
it
do
is.
my
That will be in order.
Please, the court.
preparation of judgment. Thank you very much. The matter is postponed to 30 August, that's tomorrow, at 11 o'clock.
11 o'clock, yes.
At 11 o'clock in this court. Ms. Magudumana in custody until tomorrow, 30 August.
I want to believe that then concludes the role for this court. Thank you.
Court's adjourned.
That's enough of the to you.